case number is 26CR43324. Mr. Baker is present today with his attorney, John Oshai, that is represented by Carl Harris. According to this, Mr. Baker plans to plead guilty to operating a vehicle under the influence of alcohol. That is a felony 3 that carries up to 60 months in prison, a maximum fine of $10,500. There's a mandatory prison term of 60 days required.
Right from the start, this courtroom feels offended, not just because of random distractions like gum on a chair. We're looking at a serious felony DUI case involving a repeat offender with a long history. A guilty plea is on the table, prison time is looming, and a lifetime driving ban could be enforced. But what should be a routine plea hearing quickly turns confusing. Something doesn't feel right, and what happens next could change everything. Stay with us.
The parties are making a joint recommended sentence for 48 months in prison with possibility of judicial release into a CBCF after 24 months. Further, the parties agree the defendant's license will be suspended for life. What is your plea to operating a vehicle under the influence of alcohol with how many prior convictions?
Your Honor, I show this as the 7th.
Okay.
But he does have one prior felony, OVI, which was in 2023 out of Hamilton County.
Okay. What is your plea to operating a vehicle under the influence of alcohol?
Guilty.
Accept your plea. Make a finding of guilty.
Now this is where things get serious. A felony DUI, especially a 7th offense, puts the defendant in a very dangerous legal position. The court isn't just judging this moment, but a pattern of repeated behavior. A 48-month sentence with possible early release suggests some leniency, but that lifetime license suspension, that's permanent. No second chances on the road. So think about this: should someone with this history ever be allowed to drive again? Or is this exactly the kind of punishment needed to protect the public?
CR43324. I guess does he want to withdraw the plea? Can you just do a new one?
Yeah.
He just enters the plea. I'm going to throw this away.
Okay.
Sorry, Your Honor, and thank you.
No.
Just been in the jail so long that everything echoes in there. So it kind of, messes with your hearing.
It's just not.
We got to review the camera.
Yeah, but same thing, mandatory fine, 3 to life for the class 2, and then up to...
The guilty plea is entered, but this is where things take an unexpected turn. Normally, once a plea is accepted, the process moves forward smoothly. But here, confusion starts to creep in almost immediately. The defendant appears disoriented, possibly struggling to hear or fully process what's happening. And that raises a serious legal concern, because if a defendant doesn't fully understand the plea, it could be challenged later. What we're about to see is not typical at all.
2 years discretionary PRC. Same thing that we went over before, except for the recommended sentence. Okay? Need your signature there.
Brandon, did you have anybody in here this morning?
Okay.
Somebody put gum on that chair, and he just sat there.
They're going to do a pre-sentence
I'm trying to figure out who would
investigation,
have access to that chair to put gum
and then
right
they'll
on the
come
seat.
back for sentencing. Okay?
That's bad.
It could be a YouTube sensation.
Well,
Investigation, you'll go back to the jail, and you'll come back for
no. He is now. Fine, Your Honor, it just is, it's weird, I know, I'm just trying to figure out how gum would have gotten
It
on
may
that
have come from
In the end, this case highlights just how serious repeat DUI offenses can become. A seventh conviction, a prior felony, and now the possibility of years in prison, along with a lifetime driving ban. But beyond the punishment, this hearing also shows how important clarity and understanding are in court. Even small confusion can lead to major legal complications. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.